Joe Ortona is the chair of the English Montreal School Board, and that school board was in court this morning challenging the Quebec government over some portions of Bill 96 when it comes to how school boards communicate. Joe's on the line. Welcome back to the show, Joe. Thanks for coming on.
Good morning. Always a pleasure to be here. Thanks.
Give us the update. Breaking news as you come out of court. What happened this morning?
Well, we last night we adopted a resolution to apply for a stay on the provisions of Bill 96 that we think cause irreparable harm to the way that we operate as an English language school board. And so, that's going to be filed today, and hopefully that will be heard in the next few weeks, certainly in the next few months, because a stay is something urgent that needs to be addressed relatively quickly by the courts. And, the OQLF has communicated with us now, in writing with some absurd interpretations of the law. And they're things that, we just can't be expected to do as an English language school board, to be operating almost exclusively in French.
So let's get to the heart of the matter here, right? Because there are ways that laws are written, and then there are ways that laws are interpreted. So give us some examples here of the heavy-handedness of the OQLF.
Well, I can give you a few examples. Sure. If a teacher is communicating with parents regarding the behavior of a student, even if it's an English teacher and English-speaking parents, and even if it's an English class, they're expected to do so in French. Communications between commissioners of English school boards is expected to be in French. Communication between commissioners from one English school board to another is expected to be in French. If I wanted to have an information session as the chair of the EMSB about the absurd provisions of Bill 96 and the absurd interpretation of the OQLF to those provisions, and I wanted to invite the QESBA and the English Parents Committee Association, my communication with them would have to be in French. So you see how this just doesn't make any sense, and it's, quite frankly, a further erosion of the English language's, institutions, and a further measure to dissuade the use of English in an English language school board.
What are the lawyers telling you, Joe, on this case? Because it all sounds absurd, but of course the law is the law. What are they telling you?
Yeah. Well, I can't get into the privileged communications between the lawyers, but what I can say is that we've been successful in the challenges that we've filed in the past. The QESBA and the boards obtained a stay on Bill 40. We won on the merits of Bill 40. The EMSB was successful on the merits of Bill 21. So obviously, we're confident in filing this as well. And, like with any other lawyer would give you as advice, if in anything that is absurd and that you don't agree with, the law is the law. So you only have two options. You either comply with the law or you challenge the law. And so obviously we've gone with the latter rather than the former.
So, and does that mean, like, when you're doing these communications, when you're sending a note to let's say you want to send an email to the Lester B. Pearson School Board, your counterpart over there, what are you doing right now?
Well, we're an English language school board. I mean, I'm not going to hide the fact that our meetings are in English, and we pretty much operate in English, and that doesn't mean we don't use French at all. We do use French, and sometimes when it's appropriate. But the way that they're interpreting this now is that we should be using French in almost all of the situations. The only exception is on pedagogical matters, but what the OQLF deems a pedagogical matter is being given a very strict and restrictive interpretation. Almost everything is non-pedagogical. The only thing that they're deeming can be done in English only is really things that deal strictly with curriculum.
Let me ask you, I know some people have said, well, there's the notwithstanding clause was used preemptively, so nothing can be done here. Let's just touch on that. Clearly, that's not the case. You're going to court here. So what are your hopes?
Well, it is true the notwithstanding clause was invoked, and so that restricts a lot of the challenges that could have been filed under normal circumstances. It's important to remember that English language school boards are protected under Section 23 of the Canadian Charter of Rights and Freedoms, and much to the displeasure of this government, Section 23 falls outside of the scope of the notwithstanding clause. So you can't invoke the notwithstanding clause to restrict the rights of the English-speaking community's ability to manage and control its institutions when it comes to English public language education in Quebec.
Joe, we have to leave it there. Thanks so much for joining us last second notice this morning. Appreciate it.
Thank you.
Joe
Always
Ortona,
a pleasure.
Joe Ortona is the chair of the English Montreal School Board.